Hello. How are you doing? All right. Is he med compliant? Do we know?
I believe he is, Your Honor. He did have an issue with one of the meds he was taking. He had a conversation with the probation officer about that. But other than that, he has been compliant with all of his meds and he hasn't been acting out. I do believe there was one incident where he didn't like his meds and he expressed that incorrectly. But other than that, there hasn't been any issues and I haven't received any violation reports.
Probation?
Yes, Judge.
Is he med compliant?
Judge, hard to know. I indicate whether it's or it's.
I am.
She's trying to get objective proof of that. Just let her ask.
So here's the thing. We're here, and the reason why we're here is because you have new cases, right? And those new cases are alleged to have been committed when potentially you were not med compliant. So that's why I'm always concerned and want to know if you're med compliant. Because if you're not, that will impact your bond. You understand? Because part of my job is to set conditions for bond in a probation that will make sure that you're successful, but also protect the community. Do you understand? All right. And I know we were supposed to have a contested hearing today, and everybody agreed that witnesses may appear by Zoom. I'm assuming nobody's ready for a contested today.
We did file an agreed motion. It was properly accepted, Your Honor. We are asking to reset that to either like next Monday or Tuesday, or the week after that on Wednesday or Monday, whatever's better for the court.
State defense, when do you all want the contested hearing?
And I don't know what their calendar looks like, but I know the dates that I'm available right now. Or Wednesday, yeah, the first or the third would be good for us.
All right, December 1st. And that will be a contested hearing. Witnesses can appear by Zoom. All right, once you sign the reset form, you'll be excused.
Do you want the motions, Your Honor, or we'll just do a form?
All right, Marino. Hello. Everybody, yes, bring him up. Everybody's coughing up in here. I mean, is there something going on? Something's right in the back of my throat. I can't quit talking.
There's just massive COVID everywhere.
Hey, I have never had COVID. I'm not trying to get COVID. Well, you know what? Let me reverse that, because people always want to know who patient zero is, and hey, maybe we want to do something to figure out what's in their blood. So I've had COVID several times. All right, this is final discovery.
All righty. Judge, I've got all the discovery I need. I need due diligence. We're close to resolution to the case. So we just need one more setting, Your Honor.
All right. Norma, if you can set this for 30 days for a plea deadline date. All right, December 18th.
All right, Judge.
All right, thank you. How old are you?
18.
All right, be sure to stay in contact with your attorney. All right, thank you.
Thank you, Judge.
Adrian Garcia. All right, today's plea deadline date is, have you all reached an agreement, or is this going to be a jury trial?
It's going to be a jury.
How long do y'all expect this to last? Norma, I need a jury trial date, 3 days. Sure.
Since the day I got arrested, I was whisked away in the cop car. I spent 4 months in jail, not talking to anybody. I barely spoke to my lawyer, but twice, less than 25 words, both court dates. I've seen him talk to the district attorney. Even less words than that. So I just want to be heard, Your Honor, that It was a self-defense case.
No. Let me stop you right there.
Okay.
So with regards to your, no. Here's the thing, with regards to self-defense. You're charged, according to this, with assault, family violence, choking. Yes. So with your attorney and his conversations with the state, maybe he's received all the information he needs to receive from them. For him to say that you're requesting a jury trial means that an offer has been tendered and you've made the decision that you do not want to accept the state's offer and there is no agreement that's been reached. Is that correct? I don't want to know what the offer is. My only question is,
Offers, I just want to be heard, Your Honor,
Oh.
that,
could you tender him the offer, please?
yes,
So he's gonna continue to offer, then you can let me know whether or not you have accepted the offer.
I don't mind going to trial, I'm very confident. That
All
I
right,
will-
then we're gonna give you a jury trial date.
I just, thank you, I just want to be heard, that I think I would be better off in probation, not because I think I'm guilty, but because.
But let me ask you this, and let me explain something to you. Number one, what you've been charged with, and I don't know anything about your case. The only thing I know is what's in the indictment. Wait a minute. All I know is what's in the indictment. What's in the indictment is they're charging you with assault.
This is a key legal insight moment. The judge explains how prior convictions can enhance a current charge. Essentially, past behavior can bump up the severity of a sentence. It's not just about this incident, it's the legal footprint you carry with you. For viewers, this is a critical piece of understanding criminal law strategy.
Choking. Now, normally assault, choking, family is a third-degree felony. They're proceeding on you as a second degree. So that means that they're saying that there's something else that they're alleged that's in your past. Either what's in your past is another family violence case, or either they're enhancing you because you've been to prison before, right? Now, with regards to making this a second degree instead of a third degree, if there's a jury trial, or if the state has to prove that, your attorney probably has already told you that's proved with documents. Whatever that case is, there is normally not a retry of that case. For example, if somebody's been to prison and the state wants to use the fact that they've been to prison to bump up their range of punishment, that case doesn't get retried. All they do is bring in what's called a pen packet. They present it to the jury and they have to prove that that pen packet is actually yours. And they bring that to a jury. And then with the case, whatever you're on for, that's a part of the indictment that they're accusing you of. For example, with assault, family choking, of course, they need a complainant. That's the person who's saying you did this.
I call
Then,
police.
They need that person. They need an on or about date. And they need somebody to say it was you. And then the jury will hear that evidence and the jury will make a decision on whether you're guilty or not guilty. Whether or not you believe you deserve probation or not, that's your belief. If you go to jury trial, if the state are able to prove what they're able to prove, and I don't know what that enhancement is or how they come by that enhancement, based upon that, you may or may not be eligible for probation from a jury. But whether or not you tell your side of the story or whatever, that depends on you. You have a right to testify or not testify. The state can't call you as a witness to testify, but it appears that you all are at an impasse. It appears that you want probation. It appears the state is not offering probation. So your plea deadline date has expired and you will be set for jury trial. And you all think this will last 3 days? Ms. Ferguson, I need a 3-day setting for a jury trial, and counsel, if you'll do acknowledgement of discovery. Judge, I can do February 24th. I need it in January. I can do January 13th. You say 13th? All right, your jury trial date is going to be January 13th. You're going to be brought over in whatever civilian clothing you have at the jail. If you wish to be attired in something different, there'll have to be a clothing exchange. Counselor, the new rules at the jail is that the clothing exchange must be requested within 72 hours of trial. So you can't do it 2 months in advance, or you can't do this in December. It'll have to be exactly 72 hours.
I have to request this clothing?
If he wants to do a clothing exchange, you have to file it.
Yeah, I mean, my shorts are torn because my son pushed me through.
Oh, okay.
Okay. All right, thank you. Christopher Mazuka. Hi,
Good afternoon, Judge.
been a long day.
Has been, I know, nearly there.
And am I going to be seeing you tomorrow?
No, Judge.
For mental health, it'll be Christine.
Correct, Judge. Yes.
Okay. All right. What are we here for?
Motion to revoke probation, Judge.
And are you all ready to proceed on the motion?
But I do think so Melissa was the one that conferred on this, but I believe the parties had contemplated having a TAP evaluation done in the MIT while in custody, and then depending on those results, we see how we move forward. I don't.
That's what we're more so thinking, Judge. But in the interest of expediting this matter, my client feels comfortable completing true with the hopes of treatments, and then having the TAP mental health evaluation in custody, and whatever the recommendation is by the professionals doing those exams, that the court may order that.
All right. Court is calling 2025 CR 003825 and 2025 CR 003824. State versus Christopher Anthony Mazuka Garcia. Could I have parties announced for the record for the state?
Lauren Espinoza for the state.
For the defense?
Renee Munoz on behalf of Mr. Mazuka Garcia.
And are you Mr. Mazuka Garcia?
Yes, Your Honor.
Did you review the documents in each of those cause number entitled motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And in the cause number ending in 24, are you the same Christopher Anthony Mazuka Garcia who's placed on deferred adjudication in 2025 CR 003824 for the offense of assault peace officer or judge on July 8th, 2025 for a period of 3 years?
And it was an attempted attempt to commit peace officer, Judge, I believe.
All right, so this is incorrect. All right, the motions to revoke the charge is incorrect. And let me see. And it's in each motion. It's not listed appropriately. Are there any motions to change assault peace officer to attempted assault? Any
No.
objection?
No objection, Your Honor.
All right, so in each of the cause numbers, 2025 CR 003825 and 2025 CR 003824, are you the same Christopher Anthony Mazuka Garcia who was placed on deferred adjudication for the offense of attempted assault of a peace officer or judge on July 8th, 2025 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state. And are you proceeding on the same violation in each cause number? All right, you may proceed.
By condition number 4 in Bexar County, Texas, the defendant Christopher Anthony Mazuka Garcia did then and there fail to report to the supervision officer as directed for the months of August and September 2025 in violation of condition number 4.
And how do you plead to true? How do you plead to that in each motion?
Your Honor.
Violated condition number 4 in Bexar County, Texas, the defendant Christopher Anthony Mazuka Garcia did then and there failed to report to the supervision officer as directed for the month of October 2025 in violation of condition number 4.
How do you plead to that?
True, Your Honor.
And that's true in each motion?
Yes.
Is that true in each motion?
Yes.
All right.
State will waive the remaining.
Any objections?
No objection, Judge.
All right. In each cause number, did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison in each cause number and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes, sir.
In each motion, the court will find violations 4 and 4 true. Is there a proposed agreement?
Yes, but the recommended agreement from the parties is to deny state's motion, alter and amend to add conditions at the top with mix, continue on probation, and then we will TIC the new burglary of the building and then have the misdemeanor.
Okay.
That is our understanding as well, Judge.
And what is the felony?
The number is going to be 2025 PF 43911.
And counsel, the misdemeanor, when will that be taken care of?
We can get that taken care of by next week, Judge. I think
Okay.
by tomorrow will probably be a little bit late notice, but next week we'll be able to next week's Thanksgiving. I believe, Judge, just to say confidently, I think the week after Thanksgiving, that week of December, the first week of December, we can definitely get that in.
All right. And probation, is this your recommendation?
Yes, Judge.
All right. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand. State your name for the record.
Mazuka Garcia.
All right. And where have you been? Why haven't you been reporting?
Here's the human element hitting the courtroom. Life circumstances, family loss, emotional stress intersect with legal obligations. The defendant's story shows why probation compliance isn't just a rule. It's about managing real-life challenges under strict legal supervision. This is where empathy and the law meet, and it's raw.
My grandpa died, and I got into a tough time. My mom got when she went to the hospital, and it became too much for me to be at home alone with my dad. We got into an altercation, and so I removed myself from the situation, given that I had assault charges. I didn't want to end it, so I had been staying with a friend, but only like at night, not during the day or anything. During the day, he goes to work, so I wasn't able to be there. So I was with my girlfriend, really just around in the streets, not really doing much. We spent a lot of time at the park, just just talking about our future, what we wanted to do. I was actually doing really good. I had already started employment. I was helping out right now, doing lawns. We were mowing lawns, and we already had started doing so she was going to the NNA meetings, and I was starting to join her out of volunteer because I knew I was supposed to be going to something, but I didn't understand how to get to where I needed to go or how I was gonna go about trying to do my probation. I went to my orientation, but upon leaving my parents' house, I lost my paperwork. I was just confused and scared of what to do. I thought I was gonna go back to jail immediately as soon as I went in. I know I didn't go about it the right way. I just want help. I want to get back on the right track again. I want to get back to work, and I want to get back to my girl. I have substance abuse issues. I've been working on it, and she's been a rock with me on that. Like we've been pushing each other further and further. I fully want to stop using completely. I don't want that to be a part of my life or my future. I know I'm changing from a boy to a man, and I'm trying my hardest. I really just want to help more.
Okay. All right. This is what the court will do. The court will follow your agreement, deny the motion, alter and amend conditions, take into consideration 2025 PF 43911. There's to be TAP evaluation in custody, follow the recommendations, mental health evaluation.
Final insight: the court is not just punishing, they're problem solving. Mental health evaluations, TAP programs, and felony drug court referrals are all designed to reduce recidivism and get defendants back on track. It's a reminder that justice isn't always about prison. It can also be about rehabilitation and real-life support systems.
And let's do a referral to felony drug court. I know they're at capacity, but at some point in time, maybe they'll have room for him.
Judge, do you want that felony drug court eval to be completed after the tap?
Yes. The felony drug court is a program. It's very intensive, but it'll help you if there's mental health issues. It will help you with housing. It'll help you with employment, and it'll help you with any type of drug addictions. Okay. You're welcome. So there's to be no residing in households with minors. And probation, if you can help him with resources for employment and housing. Is there anything else that you need?
I wanna. Or anything else I'm doing now, but I think you're thorough with what you're doing for me. Thank you, Your Honor.
Okay, so here's we can go off the record. Here's the thing about this court. When you're on probation, one of the worst things that you can do is just disappear. If you have an issue, just let probation know about it. If they feel like they're not addressing it,
How would I do that if I?
they have contact information for you. If for some reason you can't get in contact with him, that with him or her, you can always come back to the court. I'm always here.
So I would just come to this courthouse and then.
Yes,
say-
but first you need to try getting in contact with your probation officer, okay? But coming to the courthouse,
I don't even
I'm-
know who my probation officer is.
all right, they're gonna make sure you know. And here's the other thing. We're only here Monday through Fridays, okay? Saturday, Sunday, I'm not here. If I'm here on Saturday or Sunday, that's not good.
You're working too hard at that point, Judge.
Yes.
No, you are a very hardworking judge.
All right, thank you. Is there anything else?
Nothing further, Your Honor. Thank you for being so thorough, for allowing him this opportunity.
All right, good luck to you.